Hey, we back, y'all. We back. I'll play this the more y'all come in here. I'll play this the more y'all come up in here. We back. We got action. We got action. We got action.
Yeah, we lit. Yeah, we lit. Boy, I'm lit in the beat. You know how it goes. Stacking this money and flipping these chips. Pockets on swole. Making it rain. Watch it get lit. Drop it to the floor. Lil' mama, show me what you working with. I'ma throw this money, baby. None of this shit counterfeit. Nothing but some ballers in my VIP. You know we some pimps. Playeristic niggas in this bitch. So you know we lit. He ain't gang. Nigga, don't stand by us. You can't fucking hang. I've been getting money since legit ever since my cousin gave me my first brick. Yo, bitch, in my DM calling when I answer. I don't see nothing but her tits. All these blues on me, you can tell how I'm rolling. Big crib, but I'm kicking shit with my slime. Lil' beans will wipe a nigga nose real quick. Bitch, lit. Yeah, we lit. It's 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 lit. Boy, I'm lit in the beat. You know how it goes. Stacking this money and flipping these chips. Pockets on swole. Making it rain. Watch it get lit. Drop it to the floor. Lil' mama, show me what you working with. We get money, check the status. You know how I'm rockin'. I'm in the trap out. Nigga playing with the back end. I'ma come out with his noggin. I keep that glizzy on me in traffic while I'm with my daughter shopping. You can get parked wherever I shop. Make a nigga body pop like a drop. If I hit your bitch on the low, I would never, ever tell another soul. She said for me and she know. Every time I hit that pussy, I'ma take a soul. Twerk some, work some. I'ma keep throwing money. Pop some, drop something. Tell her where you bring more money. Lit. Yeah, we lit. It's 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 lit. Boy, I'm lit in the beat. You know how it goes. Stacking this money and flipping these chips. Pockets on swole. Making it rain. Watch it get lit. Drop it to the floor. Lil' mama, show me what you working with.
What up? I told y'all if something came up, I was gonna be back here. I told y'all. And something came up. If y'all could please hit the like button for me. I'd appreciate it. We're about to go ahead and start reading this information. I'm gonna wait till a few more people get up in here. Let me let some people know. Let me see here. Hold on. Yep. All right. What's going on, Linda B? What's good? How you doing? See it, bro. We back. Aisha. Hey, what's going on? Let me see who else.
The phrase going on is usually defined as nearly, almost. For more, ask me to give you more definitions for going on.
Thank you, Alexa. Robert Keller! What up, my bro? What's going on? What? Girl. What's up, Rob? What's going on, man? Sharice, what's going on, Queen? How are you? Alright, I'm gonna wait till at least about 20 people get up in here. It's about 2 more people. And we're gonna get rolling, y'all. Let's get this thing going. Let's get it going. So, it looks like the government has responded to their opposition. So let's see. This looks like a pretty nice one, y'all. So let's see what we got going on here. All right. Let's do this. Let's do this. Let's do this. Let's do this. Let me go right here. Okay. So, it looks like this was a response from the government sent today, August 13th. August 13th. United States versus Robert Sylvester Kelly. All right, dear Judge Donnelly. Hold on, y'all. All right, here we go. Dear Judge Donnelly, the government respectfully submits this letter in response in opposition to the defendant's motion to dismiss filed on August 9th, 2021. Defense's motion CECF docket number 159. The defendant moves purportedly pursuant to Fed R. Crim P12B to dismiss 1. Racketeering Acts 1 through 3, 7, 10, 12, 14 of count 1. Number 2, counts 6 through 9. And 3, the entire indictment for lack of venue for the reasons set forth below. The motion is both untimely and meritless. It should be denied in its entirety. So they pretty much saying, Judge, the defense is full of shit. Don't even listen to them. So first they saying that the motion is untimely. If y'all could please hit the like button, please. I got 31 in here. I got 12 likes. Help me out. The motion is untimely. It says, in a transparent effort to avoid a finding that this motion is untimely, the defendant asserts that his motion is made pursuant to Rule 12B, 2 of the Federal Rules of Criminal Procedure. Defense motion at 3. His assertion does not make it so. Rule 12B, 2 provides that a motion that the court lacks jurisdiction may be made anytime while the case is pending. Fed R. Crim P12B2. Here, the defendant does not assert that the court lacks jurisdiction. Instead, he asserts that number 1, certain racketeering acts and substantive counts should be dismissed because they fail to state a claim under New York law. Once the court dismisses those racketeering acts and counts, this results in a lack of venue in the Eastern District of New York. Number 3, certain racketeering acts related to the creation of child pornography should be dismissed because there is no evidence that visual depictions. All right, let's see what they got to say back. Here we go. Let me go to page 2. Here we go. So it says here. Hold on, y'all. It says here exist. And 4, certain racketeering acts should be dismissed because they are purportedly beyond the applicable statute of limitations. Defense's motion 5 through 13. Notably, The federal rules make clear that motions alleging a defect in instituting the prosecution, including improper venue, and a deflect in the indictment of or information, including failure to state an offense, must be raised by pretrial motion if the basis of the motion is then reasonably available and the motion can be determined without a trial on the merits. Fed R. Crim P. 12B3AI and BV. The federal rules further provide that the court may set a deadline for the parties to make pretrial motions. If the court does not set one, the deadline is the start of trial. Fed R. Crim P12C1. If a party does not meet the deadline for making a Rule 12B3 motion, the motion is untimely. But a court may consider the defense, objection, or request if the party shows good cause. Fed R. Crim P12C3. Properly construed, there can be no doubt that the defendant's motion is, in fact, a Rule 12B3 motion. Apart from his initial invocation of Rule 12B2, without more, the motion is replete with references to the fact that the defendant is challenging the sufficiency of the indictment. C.E.G. defense's motion at 3. Indeed, his argument with respect to racketeering acts 12 and 14 of count 1 and count 6 through 9 is that these racketeering acts and counts fail to state an offense because the underlying state law violations on which they rely either, number 1, do not include herpes, or 2, the indictment does not allege conduct amounting to reckless endangerment under state law. ID at 5 through 10. Nor is his meritless statute of limitations argument jurisdictional. C. Musacchio, what in the world? Musacchio versus United States, 577 U.S. 237 245 49 2016. Claim the indictment charged offenses beyond the applicable statute of limitations was not jurisdictional. Finally, his claim that the venue in the Eastern District of New York is improper falls squarely under Fed R. Crim P. 12B3AI. If y'all could please hit the like button for me. I got 41 in here. We got 18 likes. I do got my dislikes, I see. Here the court set a deadline for the parties to make pretrial motions. Following several adjournments of the trial date, on February 9th, 2021, the court set a July 19th, 2021 deadline for such motions. With the defendant's consent, the defendant moved for a 1-week extension to the motions deadline of July 23rd, 2021, which the court granted as a result of the defendant's motion, filed on the morning of jury selection, is untimely. The defendant has provided no good cause for his untimeliness, nor could he. The defendant's suggestion prior to the start of jury selection that he needed recently produced discovery to make his motion baseless. See transcript of criminal cause for jury selection on August 9th, 2021 at 6. His motion to dismiss the racketeering acts and counts. Y'all could please hit the like button for me. If you are in the bushes and you don't like this channel, you just here to see the paperwork because you just want to see the truth, please hit the dislike button. I don't care. Just at least hit the button. I'd appreciate it. Okay. Motion to dismiss the racketeering acts and counts related. Let me go back up. See transcript of criminal cause for jury selection on August 9th, 2021 at 6. His motion to dismiss the racketeering acts and counts related to herpes exposure and the correlative venue challenge are based on misguided arguments as to the reach and applicability of the underlying state laws at issue, not any substantive evidence produced in discovery. Indeed, that is why the defendant previously, as set forth below, this portion of the motion is not a proper basis for a pretrial motion to dismiss. It is clearly, as it clearly argues, evidentiary insufficiency. The defendant may not challenge a facially valid indictment prior to trial for insufficient evidence. Instead, a defendant must await a Rule 29 proceeding. Oh boy, more came out. A Rule 29 proceeding of the jury's verdict before he may argue evidentiary sufficiency. United States v. Kelly, 91 F. Sup. 2D 580 583 SDNY 2000. All right, here we go. Hold on. All right, page 3. Hold on. Where'd you go? There we go. Page 3. It says here, filed a motion to dismiss the very same racketeering acts and counts related to herpes exposure over a year and 4 months ago on March 2nd, 2020. See ECF docket number 42. The same is true with respect to the defendant's argument regarding the statute of limitations. As a result, the motion should be denied. The motion also fails on the merits. The charges related to herpes exposure should not be dismissed. Count 6 through 9 and racketeering acts 12 and 14 of count 1 can relate to violations of the Mann Act. More specifically, these racketeering acts and counts collectively allege that on or about May 18th, 2017 and February 2nd, 2018, that the defendant, number 1, transported Jane Doe number 6 in interstate commerce with the intent that Jane Doe number 6 engage in sexual activity for which a person can be charged with a criminal offense. Specifically, violations of New York Penal Law Section 120.20, Section 120.20, reckless endangerment, and New York Public Health Law 2307 or Section 2307. Exposure of infectious venereal disease. In violation of 18 U.S.C. 2421A, and 2, persuaded, induced, enticed, or coerced Jane Doe number 6 to travel in interstate commerce to engage in sexual activity for which a person can be charged with a criminal offense. Specifically, violations of Section 120.20, reckless endangerment, and Section 2307, exposure of infectious venereal disease. In violation of 18 U.S.C. and 2422A, the indictment further alleges that the defendant violated these New York state laws by specifically engaging in unprotected sexual intercourse with Jane Doe number 6, without first informing Jane Doe number 6 that he had contracted herpes and obtained her consent to sexual intercourse in these circumstances. New York Public Health Section 2307 applies to herpes. New York Public Health Law Section 2307 provides that any person who knowingly himself or herself to be infected with an infectious venereal disease has several intercourse or has sexual intercourse with another shall be guilty of a misdemeanor. The defendant argues it is undisputed That section 2307 does not include herpes. Defense motion at 4. He is wrong. Herpes is clearly an infectious venereal disease, and as a result, 2307 encompasses herpes, as New York State courts have repeatedly found. See e.g. Maharam versus Maharam, 510 NYS 2D 104 and 107. First Department, 1986. Section 2307 provides basis for valid civil claim where a husband failed to disclose to his wife that he had herpes before sexual intercourse. Fan versus Sabin, 2015 WL 5547775. At number 6, New York Supreme Court, or New York Sub Court, September 21st, 2015. In civil case, where plaintiff alleged that defendant, who was the plaintiff's ex-boyfriend, had unprotected sexual intercourse with the plaintiff, knowing he had herpes, and without first informing her of the same. Section 2307 imposes a duty to disclose, which comports with the plain meaning of the statute. See Nwozuzu versus Holder, 726 F3D 323 327, Second Circuit 2013. When interpreting a statutory provision, we begin with the language of the statute. If the statutory terms are ambiguous, we construe the statute according to the plain meaning of its words. The dictionary definition of venereal disease is a contagious disease such as gonorrhea or syphilis that is typically acquired in sexual intercourse. See Merriam-Webster.com, dictionary, venereal, 20%. Okay, here we go. Let me see, August 13, 2021 or more. Thank you very much, Purple. I appreciate it. All right, here we go. All right, it says, succinctly, a sexual transmitted disease. See www.dictionary.com, browse venereal disease. Last visited August 13th of 2021. While gonorrhea and syphilis are listed as examples in the Merriam-Webster definition, they are not exclusive examples of contagious diseases, typically acquired in sexual intercourse. According to the Center for Disease Control, and herpes simplex virus type 1, HSV1, or type 2, HSV2. See the www.cdc.org, .gov, STD herpes, STD fact herpes detailed, last visited on today. It thus squarely falls within the definition of a venereal disease, and therefore within the ambit of Section 2307. That the Public Health and Health Planning Council of the New York State Department of Health issued a response to a public comment on the unrelated regulation regarding the expansion of minor consent for HIV treatment. Access and prevention does not alter this conclusion. See defense's motion 5 and 7. The issue of whether Section 2307 covers herpes was not before the council, and in any event, the council's response to a public comment is not binding on this court. The term venereal disease is not ambiguous. In its plain meaning clearly encompasses genital herpes. New York State Court. New York State courts agree. as should this court. Finally, Plaza versus the State of Weiser, 696 NYS 2D 446 1 Department 1995 is inapposite. Defense's motion at 7. There, the court found that Section 2307 excludes HIV infection, not because HIV is not an acute bacterial venereal disease, CID, but because New York's public health law has entirely separate statutory schemes for HIV-related testing and for the examination of persons suspected of being infected with other venereal diseases. It says other venereal diseases, Plaza 626 NYS 2D at 452. The court found it significant that while there are mandatory testing requirements related to those suspected of being infected with venereal disease, the New York State legislature had specifically excluded persons suspected of being infected with HIV virus from being compelled to undergo such testing. ID citing New York Public Health Law, Section 2781, and Matter of Michael W.W., 611 NY2D 47, 3rd Department, 1994, which appears, therefore, that the Plaza Court relied on the fact following the enactment of Section 2307. The New York State Legislature had later enacted an entirely separate statutory scheme specifically related to HIV to exclude HIV from Section 2307's ambit. No such entirety separate public health statutory scheme exists for genital herpes. As a result, the defendant's reliance on Plaza is of no avail. All right, hold on, y'all. I'm live, Miss Angie. I'm here. All right, hold on. Here's more. While irrelevant to the legal analysis, genital herpes is not a relatively new phenomenon, as the defendant appears to suggest. See defense's motions 7 and 8, arguing that the concept of genital herpes was created in 1967, 21 years after the last modification to Section 2307, notably the virus responsible for genital herpes, likely jumped from proto-chimps to now extinct hominid, either Homo habilis or Homo erectus, about 1.6 million years ago. See the Washington Post.com National Health Science. Herpes was passed from chimps long before humans existed. The study finds. Okay? All right, let's move on. Let's move on. Please hit the like button if you are in here. I would greatly appreciate it. All right. The conduct alleged in the indictment violates 120.20. Section 120.20 provides that a person is guilty of reckless endangerment in the second degree when he recklessly engages in conduct which creates a substantial risk of serious physical injury to another person. Under New York law, a person that acts recklessly with respect to a result of circumstance, when he or she is aware and consciously disregards a substantial and unjustifiable risk that the particular result will occur or that the circumstance exists. People versus Galatro. 84, New York 2D 160 164, NY 1994, citing NY Penal Law 15053. As the New York Court of Appeals has made clear, the reckless endangerment statutes seek to prevent the risk created by the actor's conduct, not a particular outcome. And the risk of injury alone will sustain prosecution. Hold on. The reckless endangerment statutes seek to prevent the risk created by the actor's conduct, not a particular outcome. And the risk of injury alone will sustain prosecution. Oh, wow. Okay. Galantro 639, New York 2D at 164. Internal quotation marks omitted. Serious bodily injury means physical injury which creates a substantial risk of death or which causes death or serious and protracted disfigurement, protracted impairment of health, or protracted loss of impairment of the functions of any bodily organ. New York Penal Law 10. All right. Each of the challenged charges alleges that the defendant violated both New York Penal Law Section 120.20 and New York Public Law Section 2307, in that he engaged in unprotected sexual intercourse with Jane Doe number 6, without first informing Jane Doe number 6 that he had contracted herpes and obtaining her consent to sexual intercourse in these circumstances. Such conduct clearly meets the elements of reckless endangerment in the second degree. Indeed, the New York Court of Appeals affirmed this very conclusion in similar circumstances. In People v. Williams, the defendant engaged in unprotected sex with the victim, knowing he was HIV positive, and without informing the victim of his HIV positive status. 24 New York 3D 1129 and 1130, NY 2015, the district attorney sought and a New York grand jury returned an indictment charging the defendant in Williams with intra alia reckless endangerment in the first degree, in violation of New York Penal Law Section 120.25, which criminalizes recklessly engaging in conduct which creates a grave risk of death to another person under circumstances evincing a depraved indifference to human life. In human life. ID at 1131 and 32. The trial court held that the conduct at issue did not constitute first degree recklessness or reckless endangerment and reduced the count of first degree reckless endangerment to second degree reckless endangerment in violation of New York Penal Law Section 120.20. The appellate court and the New York Court of Appeals affirmed the trial court's decision. In so holding, the New York Court of Appeals found that the conduct did not meet the legal standard for depraved indifference. Because there is no evidence that the defendant exposed the victim to the risk of HIV infection out of any malevolent desire for the victim to contract the virus, or that he was utterly indifferent of the victim's fate. ID 1132. The risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. A person who creates such a risk must, but is unaware thereof solely by reason of voluntary intoxication, also acts recklessly with respect thereto. NYPL 1505. Let me go grab something to drink, y'all. Hold one moment. All right, I'm back. All right, here we go. So, let's move on. Says here, New York Court of Appeals, however, affirmed of the lower court to reduce the charge to reckless endangerment in the second degree in these circumstances. What's up, bro? Ain't no doubt. And let me hit you back. I'm on live. Okay. All right. The conduct alleged in the indictment as a violation of Section 120.20 thus clearly constitutes reckless endangerment in the second degree and falls squarely within the New York Court of Appeals holding in Williams. The defendant's arguments to the contrary are meritless, and the court should deny the defendant's motion. Count 1 is not barred by statute of limitations. This is what I wanted to see. This is what I wanted to see right here, because this is the part that the Warris and James Earl and all them was so excited about. This the part they were so excited about. Let's see what this says. Count 1 is not barred by the statute of limitations. The defendant's motion to dismiss based on the statute of limitations is frivolous and demonstrates a fundamental misunderstanding of RICO. Ooh. A fundamental misunderstanding of the RICO. See defense's motion at 11. The statute of limitations for a substantive RICO offense, the offense charged in count 1 is 5 years from the date of the indictment. Woo! Whoa! Oh, hell no. They gonna flip the script over there. Wow. Let me read that again, because I don't think the other channel gonna read this shit right here. They ain't gonna wanna read this right here, y'all. Let me read it one more time for them. Here we go. It says, the defendant's motion to dismiss based on the statute of limitations is frivolous and demonstrates a fundamental misunderstanding of the RICO. C, defense's motion at 11. The statute of limitations for a substantive RICO offense. The offense charged in count 1 is 5 years from the date of the indictment. C, 18 USC 3282. No person shall be prosecuted, tried, or punished for any offense, not capital, unless the indictment's found within 5 years next after such offense shall have been committed. Damn. The certain racketeering acts are predicated on violations of law, violations of state law does not mean that state statutes of limitations apply. Let's read that one more time. It says that certain racketeering acts are predicated on violations of state law does not mean that state statutes of limitations apply. As the defense bizarrely asserts. Damn. You talking about the shade. Defense motion at 11. Nor is the applicable federal 5-year statute of limitations measured from the date of the first racketeering act. This is so because the defendant is not charged with committing a particular predicate act, but rather with committing racketeering through a pattern of racketeering acts. Ooh, wee. Nor can it be argued that exposure, hold on y'all. Okay, nor can it be argued that exposure of herpes from sexual intercourse does not create a substantial risk of serious physical injury to another person. New York Penal Law 120.20, as the government will establish through expert testimony at trial, exposure to genital herpes clearly presents a substantial risk of protracted impairment of health. NY Penal Law 10.10, once contracted, herpes is incurable. According to the Center for Disease Control, the first outbreak of herpes is often associated with a longer duration of herpetic lesions, increased viral shedding, making herpes simplex virus HSV transmission more likely, and systemic symptoms including fever, body ache, swollen lymph nodes, or headache. Recurrent outbreaks of genital herpes are common, and many patients who recognize recurrences have prodromal symptoms, either localized genital pain or tingling or shooting pains in the legs, hips, or buttocks, which occur hours to days before the eruption of a herpetic lesions. See genital herpes, CDC fact sheet, detailed, available at cdc.com. STD herpes, STD fact, detailed. Last visited on, they looked this stuff up today. Herpetic lesions typically appear as one or more vesicles or small blisters on or around the genitals, rectum, or mouth. The average incubation period for initial herpes infection is 4 days, ranges 2 to 12 after exposure. The vesicles break and leave painful ulcers that may take 2 or 3 weeks to heal after the initial herpes infection. The statute of limitations generally is calculated using the date when the indictment is found under Fed Crim P6E, and for the statute of limitations purposes, an indictment is found when the grand jury returns it. See E.G. United. Oh my gosh, y'all. Whoo. Oh my. Oh my. They pretty much telling them y'all are some freaking idiots. So now we know that the statute of limitations dealing with the feds for this case, for this charge, is 5 years, within 5 years of when it was the indictment came down. 89F2D 37 and 40. Let's see what else we got. It says here, law in a substantive RICO charge under Section 1962. The defendant must have committed at least one predicate act within 5 years of the date of the indictment. Oh yeah, hey, listen. Whoever just hit that dislike, I expected that. I wouldn't be surprised if because I got 63 watching and I got 42 that some that ain't hit that like button. So I expect y'all to hit. Y'all have a right to hit the like button on this. Y'all got a right to hit the dislike button on this. Hit it. Hit it. All right. It said, let me read that again for y'all. Maybe I'll get another dislike. The defendant must have committed at least one predicate act within 5 years of the date of the indictment. Damn. United States versus Persico, 832 F2D 705 and 714 2D Circuit 1987. To establish a defendant's violation of Section 1962C, the government must prove that the defendant committed 2 or more predicate offenses, at least one of which occurred within the federal 5-year statute of limitations for non-capital offenses. Citation omitted because the indictment was filed on June 20th, 2019. At least one of the predicate racketeering acts charged against the defendant in substantive RICO count must have occurred or continued past June 20, 2014. In this case, racketeering acts 8 through 14 all occurred after that date, and there is thus no statute of limitations in this case. Dizam. Hold on, I might have something for that, y'all. I might have a, what do I got? Do I got any type of bombs in here, y'all? Do I got some bombs in here? Let me see. Matter of fact, we're gonna go ahead and get a government an applause. Great job, government. Great job. Okay, let's move on, y'all. Let's move on. Racketeering Acts 2, 7, and 10 should not be dismissed. It says here, the defendant argues that Racketeering Acts 2, 7, and 10 of count 1, all of which relate to the production of child pornography, should be dismissed because there is no evidence that visual depictions exist. Defense's motion at 12. This is not a proper basis for a motion to dismiss, and the motion should be denied. Once again, let's give it up for the government, y'all. Yeah, let's go. Woohoo! Let's go. It says an indictment returned by a legally constituted and unbiased grand jury, if valid on its face, is enough to call for trial of the charge of the merits. Castillo versus United States, 350 U.S. 359, 363, and 1956. See also United States versus Blitz, 533 F2D 1329, 1344, 2D Circuit 1976. Unless the government has made what can fairly be described as a full proffer of the evidence it intends to present at trial, the sufficiency of the evidence is not appropriately addressed on a pretrial motion to dismiss an indictment. United States versus Alfonso, 143 F3D 772, 776, and 77. It says a defendant must wait until after the close of the government's case in chief at trial, or after the jury's verdict, before contesting the sufficiency of the evidence. See Fedar Crim P 29. See also E.G. United States versus Elson, 968. F SUP 900 905 SDNY 1997. It is well established that an indictment that is valid on its face may not be dismissed on the ground that it is based on inadequate or insufficient evidence. A defendant's factual arguments challenging facially valid pleadings do not justify pretrial dismissal of the indictment. The government is entitled to marshal and present its evidence at trial, and if warranted, have it sufficiently tested by a motion for the judgment of acquittal pursuant to, let's see. Here, the initial indictment was returned on June 20th, 2019, and therefore the statute of limitations stopped running on that date. Good job, government. Good job. Good job. Good job. Awesome. Great job. Okay. Let me read that again. Here, the initial indictment was returned on June 20th, 2019. And therefore, the statute of limitations stopped running on that date. United States versus Robledo, 828 F2D 949 Second Circuit, 1987, superseding indictment made only minor technical changes to the indictment, and therefore salute told by original indictment, even though superseding indictment added a murder predicate act against the defendant. Even assuming, arguendo, that the statute of limitations was only told at the time that the grand jury issued the third superseding indictment, which is not the case, there would still be no statute of limitations issue there. The grand jury issued the third superseding indictment on March 12th of 2020. See ECF document number 43. Racketeering Acts 8 through 14 all occurred after March 12th, 2015. Okay, let's keep going. It says here, Rule 29 of the Federal Rules of Criminal Procedure, CEG, United States versus Rail, 1997, WL 58778 at 6 SDNY September 17, 1997, as the government amply states in its opposition, while defendants' arguments may properly be considered on a motion under Rule 29 of the Federal Rules of Criminal Procedure after the government presents its proof, they do not support dismissal of the indictment at this stage of the proceedings. A motion to dismiss a properly pleaded indictment confuses standards of pleading with standards of proof. ID at 7, see also EG United States versus Perez, 575 F3D 164 166, Second Circuit 2009. The defendants, however, had no basis to challenge the sufficiency of the indictment before trial because it met the basic pleading requirements that was valid on its face. United States versus Gotti. Number 2, CR 743 RCC, 2004 WL 32858 at 2 SDNY January 6, 2004. Defendants will have other opportunities to contest the sufficiency of the government's evidence, but a pretrial motion to dismiss part of the indictment is not the same nor a proper occasion. United States versus Cassie 273 F sub 2D 41 40 484 85 SDNY 2003, same as collected cases. Here the government is not presenting a full profile of its evidence. Trial is scheduled to commence on August 18, 2021. Accordingly, the defendant's motion to dismiss these racketeering acts should be denied. Great job, government. You ought to just... Oh my God. Doing such a great job here. They pretty much saying, we're not going to give all of our evidence right now, you idiots. We got a trial coming up on the 18th. What are y'all talking about? Really? Now they're going to talk about the venue in the Eastern District of New York is proper. As the defendant concedes, this argument that the venue of Eastern District of New York is premised on the court granting his motion to dismiss count 6 through 9 and racketeering acts 12 and 14 of count 1. See the defendant's motion at 12 and 13 because the motion is baseless and should be denied. The venture remains proper in this district. Moreover, the defendant is simply wrong. Once again, when he asserts that count 6 through 9 and racketeering acts 12 and 14 of count 1 are the solely alleged acts in the third superseded indictment that occurred when the Eastern District of New York ID at 12 Racketeering Act 9 related to Jane Doe number 5, which the defendant does not challenge in his motion to dismiss, is also alleged to have occurred within the Eastern District of New York, the Northern District of California, and elsewhere. See ECF docket number 43 at 11 and 12. In addition, the defendant appears to be under the mistaken impression that witness testimony regarding certain facts, including the creation of visual depictions, is not evidence. He is wrong. Oh my gosh, they are just, oh my goodness, guys. Let's give them a double round of applause for this. Oh my God, they're just nailing them to the ground. This is crazy, y'all. This is crazy. All right, here we go. Says here, conclusion. For the foregoing reasons, the court should deny the defendant's motion to dismiss in its entirety. Respectfully submitted by Jacqueline M. Kasulis, Acting United States Attorney Elizabeth A. Geddes, Nadia Shahida, Maria Cruz Melendez, Assistant U.S. Attorneys, Clerk of Court, blah, blah, blah. Wow, y'all. Wow, y'all. This is. They trying to tell them, if you really think we about to give you all of our evidence, when we about to have trial coming up, like, y'all done lost y'all minds. Y'all done lost y'all minds. All right, that was somebody said something else came out. Let me see. Miss Angie, did you wanna read the let me see what else came out. 'Cause I know you're gonna do your breakdown. Let me go in here and see what else came out. Let's see. Let me see here. Boom. Okay, that was just a scheduling order that came out. Okay, so y'all, that's pretty much it. That's pretty much it. So, look, the government not playing. They are not playing with these folks. Okay, you play the Peter remix. Karen J, y'all silly. They want them to free Akele, he ought to spell it. They don't care if he guilty, just free Akele, free Akele. He ought to smell it. They don't care if he guilty, just free Akele. That's all they care about. That's all they care about. You quit earlier. Oh, come on, Miss Ansley. Come on. Yeah, to make a long story short, as Ty said, it's denied. It's denied. It's done. This dude, they tried. Listen, they tried. They tried it though. You gotta admit they did try it. They tried it. The government was like, "No, we can't give y'all that. We can't give it to you." Oh, and y'all really expect us to go ahead and give y'all our information, our evidence, an emotion response? No, that ain't gonna happen. It ain't gonna happen. So there was some dynamite things that came out right there, y'all. Okay. Thank y'all for coming over. R. Kelly supporters, I know that this had to hurt y'all. This hurt y'all ass bad. It had to. This is not a small win. There weren't no small wins in here at all. Government just totally just ripped y'all apart. So when you hear that little lady over there that's looking up everybody's information and all that, saying, "It's a small win, guys. It's a small win for us, guys. Come on, guys. Come on, guys. Smile." When y'all hear that, y'all know she's full of shit. Y'all will be able to look at her and say, "Why are you giving us false hope?" The government just totally shredded everything. So we now understand that this statute of limitations thing that they really tried to use, the statute of limitations starts when the indictment comes down. And you have 5 years after the indictment comes down in order to prosecute or to bring your charges. Well, all right. So y'all heard it here. Y'all saw it for yourselves, okay? For those of you that didn't get it, you are more than welcome to go back and read this again. Okay? All right, y'all. I love y'all. Thank y'all for coming over. I got to get some work done for work. If anything else come out, I will bring it to y'all, okay? If you would like to pitch in to say, yo, man, we're going to help you out with this little Pacer thing. Y'all know I ain't never asked y'all for no money with the Pacer thing, but hopefully my sister do jump in to help out. I know she said, I didn't hear her say she won't gonna do it, but hopefully she do. Miss Angie told me she quit. I hope she don't quit. But either way, if y'all would like to pitch in and help out with the channel, you know what I'm saying, help out with cost on this stuff here, you don't have to. Y'all, I'm voluntarily doing this, so don't feel obligated to. But if you did want to help out a little bit, please go ahead and hit the Cash App. It is $ this blessed house. For those of y'all that don't have it, I think most of y'all already got it though. But yeah, y'all, this is pretty crazy. But this right here is the Cash App for those of y'all that do want to hit it. Just throw in, help out, whatever. It don't matter to me. All right, y'all. Love y'all. I'm sure this is definitely what we were hoping to see back from the government. I'm still waiting on Auntie Ann, though, y'all. I really want to see what Ann Donnelly is going to say, and that could drop at any time. I think that we'll see. We shall see. We shall see. It is right there. It's $. Oh, I forgot to add the doggone $. It is $ this blessed house. If you would like to be a blessing to the channel. Other than that, man, thank you so much. Thank you. Other than that, man, listen, I want y'all to understand that the defense is fighting hard for R. Kelly. They are fighting for him. They are fighting for him. And they're doing their job. These lawyers he got, they're doing what they're supposed to do. Okay? But if something come out, I will be back. I just tried to send you something, but your account. You have to try this one. I changed it, Karen A. It's the $ this blessed house. Somebody just sent something. So it works if you want to send something. I'd appreciate it. Or you can do PayPal or whatever. It don't matter. But listen, how y'all feel? How y'all feel about this, man? Do y'all feel like this was any of y'all nervous after that last motion that they put up about the statute of limitations and stuff like that? Did any of y'all say to yourselves, like, dang, they might have something here? Or did everybody in here pretty much know that it was going to be denied anyway? Yeah, that's right. That's right. Take R. Kelly, that's right. That's what it comes up under. Yeah, that's my government. Yep, that's my government. Yeah, so all right, y'all. All right. Okay, thank you, Karen. I appreciate it. Okay, sure. I will send that. Yeah, y'all. It's hold on. Thank you very much. I appreciate it. So when something else come out, y'all, I will be back tonight to read it to y'all. If it's tomorrow, I'll be right back here. And we will continue to break this case down. We'll continue to read the information. We'll continue to give y'all the facts about what's going on. It won't be no spin. It won't be no fakeness. And when y'all hear this from the other side, you're going to hear a bunch of different types of what's not read. Okay? At the end of the day, their biggest hurrah was the statute of limitations. That is what they've been waiting on. And as y'all clearly understand now, as you saw here, the statute of limitations on this federal case, on these federal charges, starts when the indictment goes down. So if the indictment started in 2019 or 2020, either one, and they had superseding indictments, then guess what? It is what it is. They got 5 years in order to take care of this. So here we go. Thank y'all so much. I appreciate everybody that hit the Cash App. I do appreciate it. Okay? Y'all listen. Yeah, Black Girl Beauty. I know a lot of people was nervous. Hold on, y'all. Hey. Yeah, I just texted to you. All right, thank you. Bye-bye. Okay, y'all. Thank you, Black Girl Beauty. I appreciate you. Okay. Oh, Aisha said she wasn't nervous. Okay. All right, y'all. Listen, I love y'all. We'll be back. We'll be back. If something else comes up, we will be back to bring it to y'all. Okay. Everybody have a blessed night, and I will holler at y'all later. Thank you, Karen. I appreciate you. God bless y'all. See y'all later. Peace.